Okay, today is Monday, March 4th, 2013. This is a statement for the court under oath. Uh, uh, this is Julio Zamora at 1385 El Camino Way, Los Banos, California, 93635. Phone number, area code 209-829-1787. I was hired at Safeway in 2002. And in 2003, I bought a lifetime medical with no premium when I retire from Safeway, so that when I retire, I don't have to pay any premium. And I paid for 5 years, so that way I could retire at any time. So this statement is got hurt on the job on 3/21/2009. This is a statement for Settlement Conference in Stockton, California, Administrative Judge Grill. And I hope he considers this statement that I'm going to make under oath to return me to work, and that Safeway Private Insurance Company replaced my lifetime medical that I paid for life with no premium. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. And she's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. On maybe a week or 2 weeks later, I ended up in the Los Banos Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is, I had a treating physician that I signed for good for 1 year, Perlosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days, and then the chiropractor to take over. Okay, so and the Los Banos Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain, and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Banos Memorial Hospital, what doctor it was, or if it was Dr. Yip or Perlosi. But they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk in and walk out type deal. And I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve. And they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks. Disability payments since I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and leave later. That didn't happen. They just flat out sent me home, and they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe and profound hearing impairment from reefer noise. Come to find out, at the settlement conference, Judge Bill's court suggested that I get a legal document for severe profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have more than a 50% hearing loss in both ears. And I should note also, for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing, they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the shop steward, "Are you an authority on severe profound hearing impairment?" And Mr. Nicewanger, the BA from Local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that they didn't safely didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other Teamsters. I returned to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Nicewanger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied, and to send all proof, photos, evidence, whatever you have, by December 25th to establish a fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary actions. And to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days, according to the contract. All Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with workmen's comp to work me for 1 year. And it was deemed accepted, whether I turned it in or not, and I had 20 days to comply or think it over if I wanted to change a job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available. And that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic because we were waiting for a document to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home, and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. and I was supposed to work first and be later. It didn't happen, and they just flat out sent me home. Again, I hate to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss, and I told them, "Are you an authority on severe profound hearing impairment?" And they just flat out sent me home. I had a settlement conference, and Judge Gill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work, guaranteed or work for 1 year. Which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Mr. or Mrs. MORLES, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, and even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce the notice of offer of work, and I'm asking for trial because I'm assuming the fact that they're in violation of 2009 Discrimination Act against severe profound hearing impairment or people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored, medical, prescription drug, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%, so I don't know what the court wants to do about that, but I'm asking for it to be reinstated. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Neiswanger, on December 17. It was stamped, received Local 439 on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also step 1 and step 2 of the contract, in which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device, or assisted hearing device at the panel hearing, and he put it in the biz and sent me home.
So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. And that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments. It's a premium lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payments to the hospital. And the union put it on workmen's comp to resolve these issues. They said I could pursue it under workman's comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that it put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before or corrected them, whatever the case is. I don't know what authority they have on changing logs. Under the Department of Transportation 395.15, 395.16 in the interpretation and 395.8, it states in there that they're not allowed to alter or change anything on them logs. If there's a problem, there's a right in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report, and it states in there that I could do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for a trial, for Judge Grill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work. and return me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks since 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of off for work. I hate to keep repeating myself, but I do have a severe, profound hearing impairment, and my life is on the line. And I need the notice of off from work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology. 1 more year. I need that 1 more year. And they made an agreement with Workmen's Comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can finish at the university. And that was a guarantee for 1 year. And I didn't start 1 day on the 10 o'clock shift Eureka run. So I'm asking Judge Grill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for familiar situations or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people, without regard to subjective bias or favoritism, based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Gill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, our transportation manager, knows all this. He knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers.
And I should like to know one thing for the record. The fact that Adam Stewart had me take a deposition, and there was no listening device whatsoever. So I didn't understand a lot of things that were going on and the questions that were being asked. I don't even remember the question. But the point is, I need to take another deposition because of the fact that I didn't have a listening device. I wasn't accommodated. And the fact that the union didn't accommodate me and Safeway didn't accommodate me. And also, I need that the unemployment office needs to be repaid all that money back from 4/17/2009 because they're in conflict of liability. I received another letter in 2012 or 2013 that Safeway is in conflict of liability because they haven't returned me to work. So I'd like to make that notation for the record for Judge Grill to consider and returning me to work as soon as possible.
The fact is, I took a QME report in October, and in the QME report,
it states the fact that he doesn't do hearing tests and the QME report wasn't complete, and that Adam Stewart didn't send me to a hearing doctor to have a hearing test, and the fact that he wrote down that I had a permanent disability and how much it was, and of the fact that I filed that I had a hearing impairment in 2009, and when I went to settlement conference, nothing was on the table for Judge Grill. The QME report wasn't complete. The severe profound hearing impairment wasn't on its table. And the fact is that, like I said before, they just flat out sent me home, and the QME report wasn't finished. And I didn't do anything wrong. I'm innocent. And the fact that they called up and the Health and Welfare Department and said I didn't work there anymore was a mistake. Because I paid for that lifetime medical, and I could have retired any time after 2003 or 4. I could have retired at any time and had lifetime medical with no premium. And I have a disability, and in fact, I didn't realize how severe my hearing impairment was. So they need to honor the notice of offer of work. They knew I had a QME report that I had a permanent disability and that I was on FMLA, and the QME report wasn't complete. And they just flat out sent me home and then said that I was fired on December 16, 2010, the union attorney, when in fact they didn't follow contractual procedures. And most important of all, they didn't notify me that I was suspended or fired or anything else. They just flat out sent me home. I can assume anything at that point, but I didn't. Because I have 200 employees underneath me and I didn't do anything wrong, and I have a permanent disability. In fact, on top of that, when the QME report was complete, I should note that for the record, that I'm deaf. I have a hearing impairment. And according to the 2009 Disability Act, which I'm protected under by the federal government, for people with hearing impairment. So, and I don't know what the workmen's comp rules are, or if the Disability Act applies in this situation. So that's why I'm requesting to go to trial. And I'm also requesting that Mr. or Mrs. MORLES replace my lifetime medical immediately by court order. For the fact that Safeway called up and I don't have no lifetime medical for myself or my family, or to cure or relieve pain and suffering from the on-the-job injury. So and I'm guaranteed that 1 year, and I need that 1 year. So again, the reason for the notation is the fact that the QME report was not complete, and it states in the QME report that he doesn't do hearing tests. So Adam Stewart was required to send me to a hearing to get a legal document, which he didn't do in October, when the QME stated and made a statement in the QME report the fact that he doesn't do hearing tests. So that's all I want to make a notation to the court, and I need to remember that to bring it up to Judge Grill in the settlement conference. A request for trial that the QME report was not complete, and it states in there that he doesn't do hearing tests. But the fact is, he did state I have a permanent disability, and I could do my job. Okay, so I'd like to know one thing, that The QME report that I took that in October, around the 12th or the 13th, or the month of October in 2010. 2010. I didn't receive the QME report, even though it wasn't complete or whatever. I didn't receive a copy until December 1st, I believe it was, when I received the notice of offer of work. And they sent me home on December 7th, 2010, just flat out sent me home. Because I received the notice of offer of work on December 1st, 2010. By then, they must have known that I needed an accommodation or a listening device of some kind, and that that they didn't accommodate me at any time, or nor the union, even though they were made aware by me giving them a prescription, like I said before, and the test results to the union attorney. So I'm asking Judge Grill to consider returning me to work, and that he approved that I take another deposition due to the fact that I wasn't accommodated. Adam Stewart had me take a deposition, and they didn't accommodate me at any time, any place, anywhere. And I should also note again that when Judge Grill wasn't at work, administrative judge suggested them to put me back to work, as well as the EDD, conflict of liability, and they didn't comply. And I hope Judge Grill considers replacing that lifetime medical that covers everything and no premium. Safeway Private Insurance Company, Mr. or Mrs. MORLES, if he can consider having them replace that immediately, because I paid for that in 2003 or 2004, and until this day, I don't know why I'm sitting here. I still don't know why they took me off work, except that I have a notice of offer of work and they don't want to work me. It's obvious because they're not complying. So that'll be my statement for the settlement conference in Stockton, California. Administrative Judge Grill, I, Julio Zamora, invoke double standards. Life is not fair, for the record.